Bankruptcy experts weigh in on U.S. and CD and small biz restructuring. Introduction. On July 23, 2019, the U.S. Congress passed the Small Business Reorganization Act, SBRA. On August 1, 2019, the Senate passed the bill. On August 23, 2019, President Donald Trump signed it to enact it. The purpose of the SBRA is to make business bankruptcy protection much less troublesome for small and medium-sized ventures. The result is Chapter 11, Subchapter V of the U.S. Bankruptcy Code, titled, Small Business Debtor Reorganization. The aim is to make it more affordable and will serve to save otherwise viable owner-managed businesses. Canadian business restructuring landscape. There are two federal statutes that legislate business restructuring in Canada. They are the Companies Creditors Arrangement Act, RSC, 1985, C36, CCAA, and the Part 3 Division 1 of the Bankruptcy and Insolvency Act, RSC, 1985, B3, BIA. To qualify for restructuring under the CISA, the insolvent corporation must owe at least $5 million. The CISA is only for insolvent companies or income trusts to restructure. Proceedings under the CISA are a very heavily court-driven process. Restructurings under the Part 3 Division I proposal provisions of the BIA are available to both companies, proprietors and partnerships. It is also available to people who owe $250,000 or more, not including any mortgages or loans secured by the person's principal residence. For people who owe less than $250,000, a more streamlined restructuring process is available under Part 3 Division 2 of the BIA. These are called consumer proposals. Restructuring under the proposal provisions of the BIA is not a heavily court-driven process like the CISA. Under consumer proposals, if all goes smoothly, there is never a court application. So we have a simpler and streamlined version for people who have a smaller debt level but are still in need of restructuring their financial affairs. The same is also true for people with fewer or no assets that need to start over through the bankruptcy process. However, there is no equivalent streamlined version in Canada for small to medium-sized businesses. Could such a streamlined business restructuring model be developed? Not only do I think it could be, as one of the bankruptcy experts in Canada holding the designation of licensed insolvency trustee, I think it must be. Streamlining the Canadian business restructuring model. The CISA is designed for large corporations. As I already stated, it is a heavily court-driven process. Therefore, I think this eliminates the CISA from developing a more streamlined version. It is not the case that it could not be done. It is just that a new section designed for simpler and more cost-effective CISA proceedings goes somewhat against the purpose of the CISA. Therefore, I propose that CISA legislation should remain available only to larger companies. Especially because the BIA, another federal statute, already includes restructuring provisions. It already has a streamlined version for bankruptcy and restructuring to avoid bankruptcy. So, why not a streamlined business restructuring section? What would a streamlined business restructuring look like? You might ask, why is this even necessary? Many small and medium-sized businesses are family-owned. There are even very large family-owned businesses. The Financial Post reports that family businesses own a bigger chunk of Canada's economy than you think, way bigger. They report it is a significant business sector contributing 35% of Canada's real gross domestic product. So with such an important business sector, it would make sense to allow those businesses on the smaller scale to qualify to have a simpler and more cost-effective way to restructure when they hit a financial bump in the road. If the viable parts of the business can be saved, it will continue to employ people, allow families to have a good quality of life and contribute to Canada's GDP. I am going to call my new section of the BIA the General Scheme for Small Business Proposals, or SBP for short. I suggest that it be a new section of the BIA, Division 1 Part 3. My 7-step plan for streamlining small and medium business restructuring in Canada. The brand new SBP will be offered to companies, proprietorships and partnerships that are established to run a business. It will be available to businesses with any kind of debt not greater than $1.5 million. A licensed insolvency trustee will oversee and be responsible for the business restructuring, will be called the Small Business Administrator. The time for the filing of a proposal after the filing of a notice of intention to make a proposal will be extended from the current 30 days to 90 days. This will be without the need and cost of a court application. There ought to be the capability to transform the rights of a lending institution who has taken an entrepreneur's home as security for a business loan or personal guarantee of such financing, and the funds were put into the business. Deeming provisions for both creditor acceptance and court approval be implemented. It is already done in consumer proposals, so why not in streamlined business proposals? This will result in more efficient and less costly restructuring. If the creditors decline or the court will not approve the restructuring, that will not generate a corporate or personal bankruptcy. Instead, the debtor simply returns to their vulnerable, financially troubled state, and they will need to deal with their creditors as best as possible. In some cases it may lead to either bankruptcy or just a closing down of the business. Where there is a secured creditor, it will lead to the enforcement of their security. Either way, it won't be an automatic bankruptcy. A director of a corporation can be released not only from statutory obligations arising from their office of director. That person, or any other person, can have their guarantee of a debt to a lender be amended if the related business debt is amended in the restructuring. There no doubt will be other areas that would need amending once all the relevant sections of the BIA were looked at. These are my ideas of the major amendments that could be made to the BIA, to allow for a more streamlined and cost-efficient restructuring for small and mid-sized businesses. What about your business? The financial restructuring process for either a large or small business is complex. The Ira Smith team understands how to do a complex corporate restructuring. However, more importantly, we understand the needs of the entrepreneur. You are worried because your company is facing significant financial challenges. Your business provides income not only for your family. Many other families rely on you and your company for their well-being. The stress placed upon you due to your company's financial challenges is enormous. We understand your pain points. We look at your entire situation and devise a strategy that is as unique as you and your company's problems, financial and emotional. The way we dealt with this problem and devised a corporate restructuring plan, we know that we can help you and your company too. We know that companies facing financial problems need a realistic lifeline. There is no one solution fits all approach with the Ira Smith team. That is why we can develop a company restructuring process as unique as the financial problems and pain it is facing. If any of this sounds familiar to you and you are serious in finding a solution, contact the Ira SmithTrustee and Receiver Incorporated team today. Call us now for a free consultation. We will get your company back on the road to healthy, stress-free operations and recover from the pain points in your life, starting now.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now.